Thank you. Good morning, everybody. Welcome to the First District Court of Appeals. We have two matters on the docket. The first docket is State of Ohio versus Gatewood C-22-616. And I see Mr. Gallagher and Mr. Souter, you're both ready to proceed?
Yes, sir.
All right, okay, you look ready. All right, and the next on the docket is In Re DK and DK, C-22-0587. And I know, sir, you're ready to proceed.
Good morning, Your Honor. Mark, I believe we have the appellant, Andy Glassman, ready to proceed this morning, Your Honor.
All right, ma'am.
Michelle Stagner for appellate, ready to proceed.
All right, thank you. All right, I'll call State versus Gatewood. And Mr. Gallagher, you have 15 minutes. Do you wish to reserve any time?
If you allow me 3 minutes, I'd appreciate it.
All right, now, I'm going to keep time on my watch.
Okay.
If you see me looking at my watch, it doesn't
I
mean
won't take
speed it up.
offense, don't worry about it.
Okay, good, all right. All right, ready when you are, sir.
May it please the court? Trial counsel's failure to recognize that his client could waive his right to a jury trial on the weapons charge really undermines any attempt by both the state and then the trial court in finding that strategy played a role in that situation. The trial court found that it was strategy, but there was no evidence in the record at all in post-conviction matters to support the idea that it was strategic. But what was in the record, both by way of Mr. Gatewood's affidavit and Ms. King's affidavit, and then the communications from trial counsel in response to a number of questions, was he didn't know that his client had the right to waive a jury trial on one of the charges and proceed to a jury on the others. And the reason that's very important in this case is because of the fact that there was unique evidence attempted to be put in on the weapons charges, specifically about the idea about whether or not there was a disability for Mr. Gatewood. It wasn't the simple matter of just putting into the record a certified conviction and saying that he has that status. There were problems with the juvenile record, and there were problems in proving that what he was convicted of was a disabled or adjudicated delinquent of a disabling offense. They called the arresting officer, who talked about the charges and talked about the act. And they spent a lot of time having communication about whether it was a felony, whether it was a violent one, whether or not it had been reduced, exactly what it was. But the idea was that in this trial concerning a violent offense, there was an extended discussion about other violent behavior by Mr. Gatewood that would never have been admissible in credibility because it was all predated, it was in juvenile court. It would never have come in under any other sort of fact situation. And then you had the clerk of court also have to come in and do all that. All of that could have been avoided in front of a jury if trial counsel was just aware of the fact that his client could waive. And because he was not aware, he did not comply with the requirements from the United States Supreme Court, Model Rule 1.2 from the ABA, and Model 1.2 from Ohio. It says that an attorney has a duty to consult with his client on those very basic trial rights. The right to plead, the right to testify, and the right to waive jury.
Let me ask you, Mr. Gallagher, and I know that your client contested that the adjudication in juvenile court. And
Correct.
I believe his testimony was that it was not felonious assault. It was he entered or admitted to a lesser charge.
Right.
So could that have been trial strategy to try to the jury as opposed to the judge who would have the certified copy of the adjudication and take your chances and see if you convince the jury that you were not convicted of?
Absolutely.
Of that? So, but could that have been strategy, though?
Absolutely, it could have been. But the problem is, what you have is evidence to the contrary, though, from own trial counsel saying he was unaware. There is no evidence, and the state presented no evidence, and no one has ever presented any evidence that there was a choice made by trial counsel. He never admits to the fact that it was a choice or they sat down. But what we do know is he never consulted with the client. And that's the first requirement. That's the very first requirement going forward, is he has to consult with the client on those major decisions. And if he doesn't do that, then he has failed at that point. We don't even get to the idea of strategy.
So, counsel, is it your position that in a hypothetical case, something like this might have been strategic? but that in this case it wasn't because of the factual evidence that you presented?
Right. Well, I think I think that we're entitled to give deference to trial counsel with most trial decisions, that they should be strategy. If not, we're going to be stopping, as the courts have said in a few cases, we're going to be stopping every way along the way, and trial courts are going to have to say, now, counsel, did you advise your client about this? We have to sort of assume that almost every decision made during trial is strategic unless there is evidence to the contrary. And in this case, there is evidence to the contrary. And that sort of goes into the res judicata argument, which is why ineffective assistance to counsel claims are different concerning res judicata and where that evidence should be. And when there is evidence outside the record, we're in post-conviction.
And can you go over that evidence for us?
Yes. The evidence is, we're talking about post-conviction. What you have is two affidavits, one from Ms. King, whose child it was, she said was sexually assaulted, which is the whole reason that they went over to the house in the first place. And you then have Mr. Gatewood's affidavit, and then you have the admissions, I think, from trial counsel. And what that is it talks about the failure to communicate with his client. And the idea that had he known, he would have made another choice. That's sort of the important thing about this. It isn't, had I known, I would have kept the same deal. And Judge Winkler, sort of in answer to your question, that's exactly the point here. We could assume strategy and that would make sense, but you have to consult with your client first and say, I think this is the best way for us to go forward. If I were you, I would not waive a jury on this because I think we can convince the jury you don't have that conviction. But what you have is two affidavits in counsel's admission that there was never that type of discussion. There was no discussion whatsoever. So he didn't know what his rights were in that instance, which is why we have all the model rules, as well as, I would say, Florida versus Nixon, and I think it's Barnes that support that has to happen. That very basic thing has to happen going forward. You could raise ineffective assistance to counsel on direct appeal, there's no doubt. And this court would be lacking any record whatsoever on the question of whether or not there was a waiver. It would be no different than if the client raised on direct appeal, I didn't know I had a right to testify. You would look in the record and you wouldn't find it in there. Or if he said, I didn't know I could just plead to this indictment, I thought I had to have a trial. And there would be no evidence in the record of it. You would always, in those instances, need evidence outside the record to support that. That's why we have the case law that suggests that you're entitled to do that. And put in the case there where you have Strickland and their comments on it, it's really inexcusable for a counsel to sort of be ignorant in certain areas. I think what Strickland says is excuse me. The inexcusable ignorance or senseless disregard of the client's rights is one of the things that Strickland talks about. And I think that's what trial counsel admitted here. I was ignorant of the fact that he had that right to waive the jury trial. You have the case of State versus Banks from back in 2015. I know it's not from the 1st District. It is from the 8th District. But what it says is when you have a repeat violent offender specification, sort of like what we have here, an allegation of a violent offense, aggravated robbery, felonious assault as the disability offense, that it was clearly not strategy and it clearly was ineffective for that trial counsel not to advise his client about waiving that right to a jury trial on that issue, repeat violent offender spec, because of the damaging evidence that would put in front of a jury when it's a status question. When it's a status question.
Mr. Gallagher, do you have any case law that actually says that a client has a constitutional right to a bench trial?
No, but what I do have is the case law that suggests that the defendant has to know and be told about his rights, and that includes waiving a right to a jury trial. So while you may not have a constitutional right to a bench trial, you do have a constitutional right to the effective assistance of counsel to tell you that you can waive that right. And I think that that's the long line of cases that starts with Florida versus Nixon and Barnes and all the way down. And that's why we have all those rules about the information. The client has the right to be informed by his trial counsel on his basic rights. And the evidence supports the fact that that did not occur here. And because that appears on the record, dismissal was completely improper in this case. The case law suggests that excuse me, I apologize, that I think it's the Blanton case and Cole, citing Cole, that the introduction of evidence that whores the record of ineffective assistance of counsel is sufficient, if not to mandate a hearing, at least to avoid dismissal on the issue of res judicata. Res judicata was inappropriately applied to this case. And as a result of that, it should be remanded to the trial court. It should be remanded for a trial court on a hearing on a question of whether or not trial counsel truly was ineffective. Because at this stage, what we're talking about is whether or not there is evidence enough to support that. You don't have to find that he was ineffective. I'm not asking that. What you have to find is there was sufficient evidence in front of the trial court for the mandated hearing, and let trial counsel testify. And if he has some other memory today that he had back then maybe the court may or may not believe that, but at least he would have to answer to the question about whether or not he, in front of a judge, under oath, whether or not he informed his client of his right to waive his right to a jury trial.
Counsel, at this point, we don't know what actions trial counsel undertook to research this particular issue or to educate himself about the law on waiving a jury on the underlying weapons charge, right? We don't know that.
Correct.
And that's
Right.
something that a hearing could flesh out.
Well, I would actually agree with you on that. And I think that because of that, and we can stop right there. What I mean by that is the evidence suggests that that's the case, but that's what we should have a hearing for. And we suggested, and I think I stand firm on the idea that we presented enough evidence in this case that we should have had a hearing and we should have stepped forward. And that's all I'm asking the court. You don't have to find he's ineffective, just that we raised enough issues and enough evidence to support that having a hearing. If there are no other questions, I'll reserve whatever time I have left.
4 minutes.
Okay, thank you very much.
Thanks. All right, Mr. Souter?
Good morning, Your Honor. May it please the court, counsel. I think what I keep coming back to in this case, and I think one of the key questions is how could the defendant's knowledge of the alternatives or lack thereof have any bearing on whether he was prejudiced in this case? And that's not to concede that the trial attorney violated any duty, but this is a case that was on direct appeal. The appellate counsel had a chance to review the entire record, and I don't see what piece of the puzzle was missing in terms of prejudice that the appellate counsel could have looked at to make a different determination about not bringing an ineffective assistance of counsel claim. It just really adds nothing to the prejudice prong. In terms of what the trial court did when in deciding whether to admit the evidence of the disability, there was no extended discussion about the specifics of the weapon under disability. In fact, the state tried to go down that road and was as appellate counsel concedes was immediately shut down on that score. I think that what we're looking at here is a garden variety Strickland claim, and the lack of consultation doesn't add anything to the inquiry about whether there was any violation of a duty to the defendant in terms of trial tactics, as the courts suggested. If there are problems of proof about an element of an offense, I think it makes more sense to take it to a jury. I think that if we look at give the standard deference to the performance of trial counsel that we normally do, I don't think that there was any violation of a duty in this case, and certainly no indication of prejudice in the record.
Well, if, Mr. Sutter, if counsel genuinely did not know that they could have tried the weapons under disability to the bench and tried the other charges to a jury, if he didn't know that, then how could it be strategy?
Well, the point's well taken, Your Honor, but my point is that when we look at the performance of counsel, what we look at is whether he fell below a standard of reasonable representation, and I think that can be gleaned from the record regardless of the level of participation that the client had in the decision-making process, or even whether or not that was a conscious decision to take this to the jury or to the bench. I think what we're looking at is reasonable. It's an objective test. Normally, we don't look behind we don't look into the mind of the attorney to determine exactly what he was thinking when he did this. We look at the record to determine if there was any violation of a duty to the client, and if so, whether there was any prejudice that resulted from it. And I think that's just simply not demonstrated on the record that we have here, even accepting the evidence to horse the record that the appellant has placed off record. If the panel has no other questions, I rest on my brief.
All right, thank you. Thank you, sir. All right, Mr. Gallagher, you have 4 minutes.
If we were to judge ineffective just on whether or not he did a really good job in all the other areas of the trial, I guess you could forget the one basic one that is here. And my opponent talked about whether or not it fell below the standard. I think based on Nixon, based on Strickland, based on Barnes and everything else that dictate what his duty in this case is to inform his client, that is the standard to which he fell below. In that regard, that's the standard he fell below. Objectively, subjectively, any standard you want to apply to it, they say you have to tell it to him. Our model rules say you have to talk to him about it, and he admits in the affidavits tell you that he didn't do that. That's falling below the standard, and that's clear. And whether it was strategy or not, I think the Barnes case tells you in an RVO situation whether it was extended or not. Putting in front of a jury evidence of a violent nature, violent charge, when it wasn't necessary because you could have waived the right to jury trial, Barnes says it was ineffective to do so. And so whether it was extended or not, they said that there could be no real strategy behind that idea about putting a violent offense in front of a jury to make that determination when that information does not have to go in front of that jury.
Can you address the role that the limiting instruction played with regard to prejudice?
Absolutely. And I think that that's exactly, but that's basically what, if you look at the Barnes case, that's sort of what they almost say. In that case, there was. You know, it's only for this limited purpose, but still it was ineffective under Barnes. It was still ineffective, even with that instruction to a jury that you can only use it to determine his status as a prior convicted violent felon. And with that instruction, the Barnes court still said it was not strategic and it was prejudicial to the defendant in this case. And on top, I mean, we don't have to talk about the evidence, but I mean, I think in our briefs talk about why we think the evidence itself lends itself to that prejudice analysis. But you can leave that up to the trial court to then determine, I think. If you have no other questions, I'll rest on my argument.
Thank you.
Oh, thank
Thank
you
you,
very
sir.
much.
All right, we'll take the matter under submission and issue a timely opinion. Thank you. Thanks to both of you. Mr. Epley, you have 15 minutes. Would you like to reserve any time, sir?
I please reserve 3 minutes of rebuttal time,
Yes.
Your Honors. Good morning to this honorable court, opposing counsel. Mark Epley on behalf of the appellant, Ms. Klosterman, who is the mother of these 2 beautiful children that is at issue in this case. There are 3 main issues regarding this case that the appellant raises. The first is an issue of de novo review that is required under the Ohio Rules of Civil Procedure, Rule 53. And as the appellee correctly points out, Rule 53 of the Ohio Rules of Civil Procedure is almost identical to Juvenile Rule 40 in the language regarding objections to a magistrate's decision. The second issue is in regards to the affidavits, or the affidavit provided by Ms. Klosterman that does not conform to the actual language in case law as to what an affidavit has to entail. And the third is the issue of due process. I'll start with the more of the important, which is the issue of the affidavit. The affidavit that was issued in this case was an affidavit of Ms. Klosterman, and specifically to her direct testimony that was not recorded on the record at the time of the trial. In order to supplement the record, the judge decided that it would be beneficial to have an affidavit submitted in regard to the portions of the evidence that was not obtained on the actual record itself. The problem with that language is that that is not an effective remedy. In order to have an affidavit, that affidavit must have all of the relevant information and all of the evidence to which the court must decide, not just select portions of an affidavit itself.
But that was the only portion of the testimony that was unavailable via transcript. I mean, do you have any case law saying that it's one or the other?
Thank you for the question, Your Honor. I appreciate that. There's not case law that I have been able to find which states that you have to have one or the other. But also in the issue of that, there is not case law which states that you may have both a transcript and an affidavit. Though the affidavit itself may be used as a supplement to the actual transcript itself, the affidavit must contain all of the information relevant to those findings of fact that were not transcribed onto the record. In the case, and I want to make sure I got it, it's State versus Baez, and I understand that it is a criminal case. The issue in regards to that is that the court may not dismiss claims based upon things that go beyond the record. What you have here, in essence, is an affidavit that does not comply with the actual affidavit rule that the court issued in this case.
Counsel, what should have happened in this circumstance? I mean, this is something that we could foresee occurring, something inadvertently doesn't get transcribed. What is the court to do in this circumstance?
Thank you for the question, Your Honor. I appreciate that. What the court should have done is either allow for both parties to submit an affidavit as to that portion of the record which was not recorded. That would have eliminated the issue of potential due process where you're allowing one party to do something that you're not therefore giving a remedy to the other party.
Your client is the one who submitted the affidavit, right?
That is correct, Your Honor.
So the remedy that you're proposing is to allow the opposing party to also submit an affidavit?
That's correct, Your Honor, and here is why. The issue that you have with an affidavit is Ms. Klosterman could have put anything in that affidavit which would then not have been subject to cross-examination. As a result of that, you have a party who can write whatever they want to, and what is in that affidavit may or may not be what is actually reflective of what the magistrate used to decide that issue.
They're not objecting. You're objecting, and you wrote the affidavit, so doesn't it inure to your client's benefit, the process that occurred?
It works to my client, again, thank you for the question, Your Honor, I appreciate it. It works to my client's advantage to be able to submit an affidavit. Yes, the problem with that admission or the submitting of an affidavit is that the language itself that is used by the court in which to only provide an affidavit to the relevant facts that were not a part of the record does not comply with case law. And as a result of that, it is a defective remedy that the court provided to Ms. Klosterman, which therefore could not be used. And the rationale behind that is if you're going to provide a remedy, that remedy has to be based in case law or based upon the Ohio Rules of Civil Procedure. And that wasn't done, which therefore means a remedy that she can't use. And if the court decides to look at that affidavit and use that remedy, even though it's defective, then the court, in admission, the court then uses additional information that the court couldn't have used in which to issue its de novo ruling on the actual objections itself. It doesn't matter that it was only going back to Judge Box's question, it doesn't matter that it was only my client's direct examination that was part of the transcript. It wouldn't have mattered if it was the last 10 minutes of the transcript that was not recorded. The whole reality of it is that you have a transcript and an affidavit that could not have been used by the court, even though it was in the issue of the objections, because of the case law, which states that you have to pertain in an affidavit to all of the relevant information and all of the relevant evidence, not just select portions of the affidavit of the trial that was not transcribed.
Well, then isn't this invited error because you prepared the affidavit? You could have put in all of the evidence and you didn't.
Well, let me be clear. So I am not the trial attorney for Ms. Klossman. So that was done by trial counsel with the affidavit. But again, that therefore goes to the issue of due process. Again, Ms. Klossman could have put whatever she wanted in the affidavit, but that wouldn't have necessarily, A, reflected what was on the record as to what was stated in the actual trial, and B, if it doesn't, then you have an issue where you have a opposing side that can't now come back and say, that's not really what was testified to.
But why, I'm struggling to understand your point, because it was your client's affidavit. You're right, she could have put in there whatever she wanted. So, as Judge Kinsley pointed out, that's to her benefit.
But that, and thank you for the question, Ron, I appreciate that. But that gets to the issue of going outside of the scope that the court used in which to make a decision.
But it's, okay, Juvenile Rule 40D allows this to happen. So how was it not a part of the record?
Because what you have is you have a record that was made by the magistrate in which he issued his decision based upon the issue of witnesses and the credibility and things to that effect. When you take out a portion of that, you do not have a complete record.
Well, you do, because Juvenile Rule 40D allows that.
When you take away one of the testimonies of a party, you don't have a complete record. What you have is you have two records. You have an affidavit and you have a transcript. And those in and of themselves don't mean that you have a complete record. What you have is a 2/3 or 3/4 of a record based upon the transcript, and you have 1/3 or 1/8 or whatever the time is that you have based upon an affidavit. That affidavit, if it goes beyond what the magistrate looked at, that goes beyond the scope of the record as far as what is testified to.
Let me ask you this, Mr.
Yes, sure.
Eppley, and I know your client testified as if on cross-examination, so that her testimony is in the record that way. She also testified, and unfortunately the machine that was supposed to tape her direct testimony was not on. But looking at the magistrate's finding of facts, conclusions of law, summary of the evidence, he went into great detail as to your client's testimony, her direct testimony, which would have been supplemented, of course, by the affidavit. And it seems to me if there was, the judge looked at everything, looked at the affidavit, if there were discrepancies between what the magistrate recalled as part of your client's direct testimony in the affidavit, somebody would have said something, I assume. Do you understand my question? That it's a very detailed decision, long decision, summarizes all the evidence. And the trial court had that in front of the judge when she reviewed the record and adopted the magistrate's decision.
Thank you for the question, Your Honor. I appreciate it. The problem that you have is that you have a record which does not necessarily comply with what or comport with what the magistrate heard at the time of the hearing.
But wouldn't Ms. Stagnero have jumped up and down if that were the case? She didn't file anything in opposition to the affidavit.
That's correct, and I appreciate, again, the question, Your Honor. The problem that you have is that when you have any portion of that record which is defective by what the remedy is, you do not have a remedy. You have a false remedy or a pseudo remedy, which makes everyone feel comfortable that we have a complete record, and now we can go forward and issue our ruling on the objections to the like. But the problem is when you have a defective remedy, you have no remedy at all. And going to your question, it wouldn't have mattered whether or not the court issued a 300-page, the magistrate issued a 300-page decision and literally outlined every element of what he looked at in order to make the ruling, because the judge is the one who gave the right to Ms. Klossman in which to make an affidavit. And that affidavit does not comply with case law. The real issue with all of this is she says the judge issues and says, I'm going to, in order that you submit to an affidavit that goes through the testimony, and I'll read the actual language that she issues on the 4th of August. She said, the court hereby orders mother to submit an affidavit of the evidence presented that was not able to be transcribed. And the case law in and of itself says it has to have all relevant evidence, not just a portion of it, which
Well,
means.
Okay. First of all, there is case law where the court has permitted portions. For example, in Vogel versus Campanaro, 26 minutes was missing, and the affidavit was ruled to be fine. In that case, it was under the civil rules. I'm really struggling to understand how this does not comply with Juvenile Rule 40D. It is, what was submitted was an affidavit detailing the missing transcript, or the missing testimony. So I don't understand your argument.
No, and I appreciate that, Your Honor. The issue is that when you provide the relief to provide an affidavit, if that affidavit does not go through all of the evidence that is necessary, then the court can't use that affidavit. Or even if the court does.
Counsel, your client prepared the affidavit. So even assuming that we agree with you and we interpret the rule and the case law as broadly as you're asking us to, and that's an if, your client is the one who prepared the affidavit and who would have been responsible for putting all of the evidence in the affidavit. So how is there any error that occurred below by anyone other than your client under your interpretation?
Thank you for the question, Your Honor. I appreciate that. The issue is that the courts speak through their record. And as such, you have a record which shows that the affidavit has to present the information that is part of the evidence on the record. That's the language in the order. That does not comply with what a supplemental affidavit must include, being all portions of all of the evidence, not just a part of what they want to have a selective portion of the actual
But
transcript.
who would have put all the evidence in an affidavit? Who would have done that other than your client?
Nobody would have, thank you again for the question, Your Honor. Nobody would have put all of the evidence in the language or in the affidavit because they were not told to do so. That was not, and I see my time's short. They were not told to do so.
You have 57 seconds.
They simply followed the order of the court to provide an affidavit in supplement of the transcript. I'll reserve.
So are you suggesting that, since you seem to have an issue with the fact that the trial court considered evidence that was different than the magistrate, so are you suggesting that your client should have been ordered to produce an affidavit of all of the evidence, and that's what the trial court should have looked at?
That is correct, Your Honor.
So how would that be better? I mean, if your argument is that the trial court heard evidence that was different from what the magistrate heard, then how would, if the affidavit covered the entire hearing, how would that be better?
Because, thank you again for the question, Your Honor. That would have at least satisfied the requirement that all of the evidence be a part of the affidavit, which is required under the statute or under the civil rules, Your Honor. You don't have that. You have select portions, albeit it's one piece of testimony. You have select portions of an entire record. You have an affidavit, which the court used. You have a transcript, which the court used. And the affidavit, if considered to be defective, then the court couldn't have issued a de novo ruling on the magistrate's decision because the court couldn't have relied upon a defective affidavit in which to go ahead and issue an order of the court based upon what was presented in the hearing.
Wouldn't that have been extremely expensive and burdensome to your client to have to go back and produce an affidavit documenting what already existed?
And I appreciate the question, Your Honor. The issue of fairness has no value. And in reality of that situation, I'm pretty sure my client would have found the funds in which to do that. This is an issue of fairness and due process and protocol. And she would have done that if that's what the court had asked for her to have done. If I may, I understand my time is up, I appreciate that. If I may go back to the question that you asked.
I'm going to have to stop you, sir. You're like -3 minutes.
I'm sorry, Your Honor.
You used all your rebuttal time, but I'll give you rebuttal time. We've been asking you a lot of
Yeah,
questions.
no, and I appreciate that, Your Honor.
At some
Thank you.
point. Thank you. All right, Ms. Stagnaro.
Good morning, Your Honors. Mr. Epley. It looks like the most significant issue is this affidavit, but I think the court has an idea of what was in our argument, and that the trial court properly considered this affidavit and properly ordered that the affidavit be prepared. What we have is a complete transcript, but for mom's direct testimony. So we have her as if on cross, which took up the bulk of the transcript. We have all the witnesses who testified. We have my client who testified. The only portion of the transcript that was not transcribed was mother's direct testimony. And understandably, the court under Juvenile Rule 40D can have the transcript supplement the record, which is what the court ordered, to give mom the opportunity to present that direct testimony so the court could do a de novo review. So it gave her that ability to make a record that didn't actually exist. To go back and say that mother should have presented testimony of the entire trial makes no sense. We have a transcript of the entire trial with the exception of her direct testimony. She was then given the ability, and it wasn't even a written statement, it was actually a transcribed statement. So it was as if she were testifying without the benefit of the judge being there to rule on objections or for father to object. She could have said whatever she wanted for as long as she wanted, because it was her direct testimony, and nobody would have been able to check her on it. And my client did not object to that transcript coming into evidence, so the court could make a de novo review. So as all of you have said, I don't understand the issue because this was mom's affidavit and her ability. It could have only have benefited her. Unfortunately, it didn't, because as throughout the whole case, as I put in my brief, she could not tell the truth. She could not say the same story each time that she was under oath. She said something different in her deposition than she did in cross-examination and in her direct testimony at trial and in her affidavit. And the court looked at that to determine that she was not credible in what she was saying. That is nobody's fault. It's certainly not the trial court's fault. That is mother's fault if she wasn't going to be consistent with her own testimony. So the court was certainly permitted to allow that transcript to be submitted, or the sworn statement, the affidavit, under Juvenile Rule 40D. The trial court considered it. It was filed as part of the record. The trial court considered it in making her decision. There is no due process argument. Mother had the opportunity to be heard multiple times in different forums, as I said, in deposition, cross-examination, direct testimony. And I think, Judge Winkler, you pointed out the magistrate was extremely detailed in what each witness testified to. That doesn't happen in most magistrates' decision. He pretty much went through and summarized every single thing that everybody said and put that in his decision. So the trial court had the benefit of all of that when making her decision.
Counsel, it seems like the real crux of the magistrate's decision and then the judge's ultimate findings in this case rested pretty heavily on mom's failure to work with dad to provide parenting time and to involve the father in the lives of these children. And it seemed to me like most of that testimony came from witnesses other than mom's direct. So that even if we were to say there was some kind of flaw in this process, that there's still plenty of evidence in this record to ultimately justify the trial court's holding. Can you address that aspect of this?
And I absolutely agree with that, Your Honor. I mean, the testimony, even not just from father, but from the other witnesses that testified, clearly laid out that mother had done everything in her power from the time these children were born, or even before that, until the time of trial, which was about 4 years later, 3 years later. to keep father out of these children's lives. I mean, she lied about whether he was the father at all, and as a result of that, he moved to Wisconsin to start over and only found out later that he was actually the father of these children. He immediately filed, once paternity was established, to be able to have contact with these children, and despite court orders to the contrary, mother consistently denied father parenting time, or she would violate the court orders. She would not communicate with him. She said in her testimony, basically, she considers father to be a stranger to these children, that she did not see him as any parent whatsoever to these children or have any value to these children's lives. And she made that pretty clear, even not only in her own testimony, but in what everybody else said, that she clearly did not value him as a parent, and she wasn't going to. Even in her own testimony, she said she was already setting up the fact that this drive was going to be too much for her, almost to say, I'm not going to comply with this court order moving forward. I think the magistrate, in looking at all the testimony, everything that was presented, clearly there was substantial, credible, a lot of competent evidence that mother was not going to comply with court orders. She was going to continue to cut out father from these children's lives, and as a result, awarded custody to father.
So the fact that she had violated previous court orders, does that bolster your argument that she will continue to not follow court orders?
Absolutely, and I know that the court considered that. For a while through the process, the magistrate was more encouraging of saying, you should allow, father should have parenting time, you should work together to have parenting time. So there wasn't, I don't know that that was an order, but it was certainly a very strong recommendation. Yet mother continued time after time to not follow that recommendation until finally there was a court order, and she still played games and still denied my client parenting time. So her behavior over a significant period of time, again, we're talking years that this case pended, she never really followed any recommendations or order of the court. So if I'm the trial court, and what the trial court did is say, this has been the pattern, I don't see that changing, even though we're in court and you should be on your best behavior right now. If you're not doing that while you're in front of me, I am certainly not going to expect you're going to do that once you're no longer in court before me. So for all those reasons, we believe, number one, the court made a full de novo review of all the evidence. I think the trial court set forth that pretty clear in her decision. The affidavit, I think we've addressed, and then finally, whether the court made the ruling in the best interest of the children. Clearly, father being designated the residential parent is in this children's best interest, given all the factors. The court considered all those best interest factors and made the appropriate decision. So we're asking that the court's decision be upheld. Thank you.
Thank you. All right, Mr. Epley, we asked you a lot of questions. I'll give you the 3 minutes.
The court, in its line of questionings to opposing counsel, talked about what the monumental evidence was that may have been against Ms. Klosterman. But despite the fact whether or not Ms. Klosterman was truthful, not truthful, encouraging, not encouraging, it doesn't defeat the idea or negate the idea that she's entitled to due process. In the issue before the court in N. Ray H.L., which is a First District Court of Appeals decision, there's a due process test.
That was a termination case, not a private custody case between two parents.
That is correct, Your Honor. I appreciate
And that was about terminating parental rights. In custody cases such as this, the parents retain parental rights. So how is it a due process issue?
There are 3 factors that the court considers, and regardless of whether or not it's a termination of parental rights or whether or not it's an issue regarding adoption or however the court wants to phrase it with family law, there are 3 fundamental portions that have to be followed under that case law. And it's an issue of a fundamental right. Mom has a fundamental right to be a parent. The court has addressed that. The issue of the risk of erroneous deprecation of such interest through the procedures themselves, we have addressed that issue. And then the issue regarding what the Honorable Judge Kinsley had asked about how expensive this is. The issue is that there is nothing that prevents mom from spending this money to go back and to recreate the record. And going back to what the Honorable Kinsley had asked earlier, what Ms. Klosterman would like to see happen is either a reversal of this decision, or, if nothing else, to have the case remanded back to either the magistrate or to the judge for a full hearing on the matters in which to have a complete record, therefore be able to be submitted.
Well, didn't the magistrate quit? You'd have to start all over, I think.
That is correct, Your Honor. I appreciate the question.
Maybe-
But even then, it would be a question as to whether or not the magistrate would be an independent party, knowing that he's already heard all the information and has already issued a ruling, and therefore would have to go back before a different magistrate, or considering that the judge is not on the bench anymore, it would go back before a different judge. That at least solidifies the issue as to what is being asked for by Ms. Klosterman in order to show that there is a complete record that is not part and parcel of different people's testimonies.
You have 15 seconds. You want to say anything else?
If there are no further questions, we'll ask the case that be submitted to the record, Your
All
Honor.
right. Thank you, Mr. Epley. And
Thank you, Your Honor.
Thank you both. We'll take the matter under submission and issue a timely decision. Thank you.
Thank you, Your Honors.